It's a big win for the presidency, even though they left some things in place there, something for the chattering class to bump its gums about. But $500 million or more with interest is gone. It's just gone, right? It's not coming back, is it?
Well, it's a 323-page opinion, actually 3 different opinions. The court split 2 to 1, and trying to figure out what the actual majority ruling is going to take a master chess maker to figure it all out. One of the judges said that the whole case has to be thrown out and dismissed. That was Judge Friedman. 2 of the judges, Higgett and Rosada, said there were so many errors in the trial that it has to go back for a new trial, which means not even liability can stand, and they got to try that again. But oddly, those 2 judges joined with the other 2 judges and said who had found there is liability, but that the fine was too excessive and had to be thrown out. And the reason that Judge Higgett and Rosado joined with those 2 on that liability finding is to create a final decision by this intermediate appellate division so that it can go up on appeals and they can decide whether, in fact, Judge Friedman in dissent is right at all, the whole thing should be dismissed, or where there is some liability, but we've got to have a more reasonable fine imposed. And I think there are serious questions about whether the statute they were operating under even can constitutionally be applied to the context of this case. The statute is a vague, the attorney general can prosecute or bring actions against anybody in the interest of securing an honest marketplace. Now,
whatever that means.
And it's designed to be a consumer protection statute. There were no consumers harmed here. There were no banks harmed here. And the use of this statute is such a stretch that I think it violates due process. And those are the kind of questions that'll go up on appeal now.